Hi, Larry Parman. Here today, broadcasting from Austria, floating down the beautiful Danube River on the top of a Viking cruise ship. We're headed toward Amsterdam from Budapest, and I guess we're about a third of the way through the trip. Anyway, great scenery, just wonderful communities. You know, the trip's a little bit of it's almost flirting with you because you have a one-day stop in some of these extraordinary places, and it makes you want to stay 3 or 4 days. You don't have that opportunity on this trip, but nonetheless it gives you a clue about where you'd like to come back to and visit in greater detail and with more time. All right, today a little bit about limited liability companies. So many times people come in and they have an LLC, limited liability company. They have correctly formed the LLC in the Oklahoma Secretary of State's office. Maybe they've even secured an EIN number, but most often they have not, because they are assuming that their entity will be treated as what's called a disregarded entity. More on that later. And therefore they don't need an EIN number. Everything will be reported on their 1040 business as usual. Well, theoretically that might work, but there are multiple reasons why after the formation of your LLC, why after receiving your articles of organization, it's mandatory that you have an operating agreement. Think of it this way. An operating agreement is to an LLC as bylaws are to a regular corporation. So I won't have time to cover all the reasons why one should have an operating agreement, but let me just touch on a few. So, first of all, the primary reason to have an LLC in the first place is asset protection. Well, courts traditionally require that some formalities exist in order to create separation between individual ownership and corporate or LLC ownership. Those formalities help protect the LLC status. So it identifies that in fact you do have a separate legal entity and that entity is entitled to all the statutory protections that one thought they were getting when they set up the LLC in the first place. Again, the primary purpose of an LLC is for asset protection. And in many states, including Oklahoma, and I'm getting away from my point here a little bit, but a creditor, an outside creditor, has only a sole remedy, an exclusive sole remedy against the owner of the LLC. And that comes in the form of what's referred to as a charging order. So if a judgment's taken against you, the creditor can, in effect, post a yellow sticky note on the outside of your LLC, but cannot penetrate the LLC, take over the management, force the sale of the assets, force the liquidation of the LLC at the courthouse steps, as can be done with a regular corporation. Again, that's the asset protection feature. You want to be sure that that is preserved in every case. Now, there are multiple other reasons to have an operating agreement. First of all, it clarifies ownership. This is particularly important if you have more than one member or more than one owner in the LLC with you. So it helps resolve disputes, it helps identify percentages owned, and so forth. It also creates a management structure, which can be critically important. It can identify whether or not the LLC is what's called a member-managed LLC or a manager-managed LLC. I prefer the manager-managed LLC because that identifies a clear chain of command so that if A cannot serve as the manager of the LLC, then B will serve as the manager. It's much like naming a successor trustee in a trust. So again, it provides continuity of management, clarity about management, and so forth. Another reason is that when you go to open bank accounts or do business with financial institutions, they are going to want to see a copy of the operating agreement. And again, this will just create credibility for you and legitimacy in terms of how financial institutions see you operating. Again, many other reasons, we can talk about that later, but I just wanted to alert you to this fact. It's critically important to have an operating agreement when you create an LLC. If you have any questions about that, feel free to give us a call anytime. Happy to visit with you. Signing off for now. Take care.
If you would like to learn more about creating an estate plan for your family, protecting your assets if you have to go into a nursing home, or transitioning your business, call 405-843-6100 or send an email to info@parmanlaw.com. That's 405-843-6100 and info@parmanlaw.com. Thank you.